Your Honour, Mr. Jason Davies, wearing the purple tie, is on the screen, and he's accompanied by a legal representative who would announce himself. To Your Honour.
Good afternoon, mate. Please the Royal Commission. My name is Macmillan, spelled MCMILLAN, initials BI. I'm a barrister instructed by the Crown Law Office of Queensland. I appear for the State of Queensland and Mr. Jason Davies. I understand the State of Queensland has been granted leave to appear in this case study.
That's so. So you have leave to appear.
Thank you, Your Honour.
It's Mr. Davies, isn't it?
Yes, Your Honour.
You'll need to be sworn. Have you got a Bible, or do you want to take an affirmation?
Affirmation, please.
Yes. Would you stand for me if you could? And just repeat after me. I do solemnly, sincerely and truly.
I do solemnly, sincerely and truly.
Declare and affirm.
Declare and affirm.
That the evidence I shall give in this Royal Commission.
That the evidence I shall give in this Royal Commission.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Yes, thank you. Take a seat. Yes, Mr. Stewart.
As Your Honour pleases. Mr. Davies, would you state your full names for the record, please?
Jason Peter Davies.
And Mr. Davies, do you have with you two statements by you provided to the Royal Commission, one dated 8 July 2015 and the other dated 20 July 2015?
I have my two statements, yes.
Is there any respect in which you would like to correct or amend the statements?
No.
Do you confirm them to be true and correct?
I do.
I tender the statements, Your Honour.
The first one will be Exhibit 2911. That's the one of the 8th of July. And the second one, Exhibit 2912.
Mr. Davies, you are presently employed as the Principal Legal Officer at the Department of Education and Training for the State of Queensland, is that right?
Yes.
And you were admitted, you are a barrister admitted to practice in Queensland?
Yes.
And you have been since September 1998?
That's correct.
And as I understand it, prior to commencing your present role, you were a legal officer at the Office of the Director of Public Prosecutions?
Yes.
And you were in that position from August 1999 until August 2003?
Yes.
And was it in that capacity that you came to handle the prosecution against the person known in these proceedings as BCH for offences in relation to the abuse of his daughter BCG?
Yes.
Can you explain when in the proceedings, in the criminal proceedings, you became involved?
I was a case lawyer in the Office of the Director of Public Prosecutions. I worked in what was known then as the Committals Work Group in Brisbane. The Committals Work Group handled matters conducted, committals matters conducted in the Brisbane Magistrates Court. And I took over a particular cipher within the Committals Work Group. The cipher was known as CPA, which is a designation they give to a particular position. The lawyer before me in that position was Belinda Merrin, who's now a prosecutor. I took over her files, and one of those files was the one involving the people you've mentioned. And at that point in time, the proceeding was a part-heard committal. I think 2 days had already been heard in the matter, and I had about 1 day to go to conduct the committal. And that's really the context in which I came into contact with the matter.
And thereafter, did you have the conduct of the matter in its preparation for trial in the district court?
Yes.
And
sorry.
You finish.
Which entailed simply preparing a précis, which is described as a schedule of facts in the material for the prosecutor in preparing the indictment and attending to the instructions for the presentation of the indictment.
So is it the case you didn't personally prosecute the matter?
No.
Now, were you involved in the capacity you've described right through the case until ultimately conviction and sentence?
No. I was involved from memory. Really, the way it worked in the Office of DPP was you would, in terms of being a preparation officer, you would be responsible for a file up at you'd have core responsibility for a file until the indictment was presented. And then, in effect, the file would move then, would sit in your cupboard until it was allocated to a prosecutor, and then the prosecutor would effectively take carriage of the matter. They'd have a clerk that would assist them from the office, and then they would mainly rely upon that clerk and police officers until the matter was resolved. They'd only come back to the case lawyer, really, if there was something specifically they wanted the case lawyer to do. And I don't recall, for example, in the remaining time that I worked at the Office of the Director of Public Prosecutions, anyone coming back to me specifically about this matter, except, I think, to advise me of the outcome of voir dire in relation to the first trial.
And what were you advised in that regard?
It was in relation to the admissibility of some inculpatory statements made by the accused. I'd formed a view that we might have some difficulty in relation to that, and I was advised subsequently that they'd been excluded on voir dire. Well, that's what I recall anyway.
Now, I understand from other evidence that there were 3 trials. The first resulted in a hung jury, the second a mistrial, and then the third a conviction on a number of counts. Is it the case that those outcomes were not reported to you over time?
No.
Now, the schedule of facts that you've spoken of, I don't know, do you have a copy of it with you by any chance?
I do.
Right, and we have it here. It's at Tender Bundle tab 37. In the form in which you have it, Mr. Davies, does it have a ringtail reference in the top right-hand corner?
It does.
Can you identify the reference of the document you're looking at?
It says QLD full stop 0068 full stop 001 full stop 1267.
Right. And there's a statement in that schedule of facts in capital letters in the middle column which says a crucial factor in this trial is the social environment created by the congregation of Jehovah's Witnesses, which has strongly influenced the behavior of the defendant and all witnesses. Did you cause that statement to be recorded there?
Yes.
Why did you write that, Mr. Davies?
I had done a lot of preparation of offence matters involving sexual abuse of children, but this matter stuck out for me because I really had no exposure to matters involving the Jehovah's Witnesses. And when I read the material, conducted the last day of the committal, had spoken to the complainant, I think on more than one occasion, I formed the view that it was important that whoever subsequently had the file after I'd done the initial preparation work should instantly know that there was a context that underpinned the whole case. And I think perhaps I was just naive and that I had no understanding of the Jehovah's and how they approach these type of matters. To be frank with you, I'd assumed that any adult who had heard the type of complaints that the victim in this case mentioned would instantly go to the police. So really what I was doing by putting that on the schedule was just making sure that people were alerted to the fact that this was not a run-of-the-mill type of matter.
Beyond what you've explained with regard to going to the police, is there anything you were referring to in saying the influence and behaviour of the Jehovah's Witness faith?
Yes. It also, I think, covered off 2 other matters, in my thinking at least. One was the time frame, an explanation for the time frame between the allegations first being made by the complainant and then subsequently coming to the attention of the police, which was a period of some years. Just being in working in the Office of the Director of Public Prosecutions, you become aware that it's not uncommon for defence counsel, particularly in so-called historical sex abuse cases, to raise delay as almost a form of impeachment of the complainant. So that part of my thinking there was that this would be partially to explain, when you looked at the evidence that the complainant gave, her faith was a significant explanation for why it took so long for her to go to the police. Secondly, it related to the circumstances in which the accused made the inculpatory statements I referred to earlier, which was something I'd never encountered before. I considered highly unusual, and I considered that it would have an impact on the admissibility of those statements.
And do you recall what those circumstances were?
In terms of the inculpatory statements?
Yeah, the circumstances of the inculpatory statements.
The circumstances were that he went before a couple of committees of the Jehovah's Witnesses and had allegations put to him in front of a panel of elders, and he gave a response and they made findings. That was one aspect of it. It was kind of like a court proceeding in a way. The second aspect is that he, as part of his faith, as it was explained to me, I think possibly by the complainant, was that the more truthful he was at a certain point, the more chance later on he would get to be returned to the faith after being disfellowshipped. So two aspects, I suppose. One, he was encouraged or required to be truthful by the tenets of his faith, and the second was the more truthful and honest he was, the more chance that his punishment would end early.
So the one aspect you've identified is the delay that's caused by the handling of the matter internally to the church. Are there other consequences that you experienced in the preparation of this particular case that the handling of the matter internally to the church caused?
I'm sorry, I don't understand your question.
You've explained that because the matter was handled internally to the church and not reported to the police, there was a considerable delay before it was ultimately reported to the police. And you've explained,
that's correct.
You've explained the problem with the delay. Were there other difficulties that arose because of the manner in which the matter was handled internally to the church?
To my thinking, the only other major problem was in relation to the admissibility of the accused's statements. I think that there were the other problem that I didn't focus on as much because it didn't necessarily impact directly on the prosecution of the matter, but I acknowledge it, is that the way the complaints were handled internally by the church must have had a terrible impact on the complainant, and it led her complaints to be exposed to a very wide variety of people, more so than you would normally see in a sexual abuse case, where a young victim would speak to maybe one other person perhaps, and then the matter would end up in the hands of the police. In this particular case, the complainant was forced to go before at least 3 other members of the church. I think her mother was present, her father was there. I'm not sure whether any other persons were there. That was only on the first occasion. On the second occasion, it was even a bigger panel. And these are at least on the first occasion, people who live in her local community. So undoubtedly she was subject to some gossip and innuendo that might have resulted from the revelation of those matters.
And whether in this case or more generally, do you conceive of there being potentially a difficulty with regard to the contamination of evidence?
Yes, that's true. Probably not as important in this case because of the age of the complainant and the relevant consistency of her statements over the years. I wouldn't have anticipated that as being specifically necessarily a problem in this case, but potentially in other cases, yes. It's true to say that the fewer people who discuss the matters directly with the complainant, the better, at least until it's in the hands of the police where they conduct a proper interview process with non-leading questions.
Now, I don't wish to put you on the spot on a legal question, Mr. Davies, but you may be aware that in New South Wales and Victoria there are statutory offences for the concealment of certain types of offences. But I understand that there's no such statutory offence in Queensland. Would that be right?
I understand that the relevant law, which would have been misprision of felony, ceased to be in operation in Queensland many years before I became a prosecutor. I think, from memory, possibly in the 80s.
1985, my research tells me, Mr. Davies.
There you go. It was only an educated guess on my part. But that really meant that you didn't have the same, I suppose, prosecutorial influence over people in terms of them reporting offences. So technically I don't think that the elders in this case committed any offence at the time by simply failing to report the matter. And, you know, in Queensland there still isn't a general offence of failing to report these type of matters, except in limited circumstances where you might be a mandated reporter in a particular professional occupation, such as teachers, doctors, police officers, child safety officers, etc. I've done a lot of work on that type of stuff in my capacity as a lawyer for the Education Department.
Mr. Davies, do you know the motivation for legislating to do away with the misprision law?
Look, no, I don't. The only reason I know about it at all is because I've had to do research on the issue in terms of my current employment to see what the laws were and how they affected departmental staff. And I had access, I think, to an Australian Law Reform Commission report that had some background research. And all I needed to know was it didn't exist anymore and there wasn't anything else to replace it.
Tell me, you may not know the answer to this off the top of your head, but is a Sunday school teacher a mandatory reporter under your legislation, or would they be?
Very unlikely, because it would only apply if they were a registered teacher.
They've got to be registered.
You have to be a registered teacher.
Right.
Part of that, I mean, I don't wish to say I'm an expert on the matter at all, no. But that was a limitation that was imposed in the adoption of the Carmody report that occurred in Queensland a couple of years ago into child protection, and a lot of thinking was done about how you would define specifically the people that were going to be caught, and I was part of the discussions, I'll admit, and I think coming up identifying people as registered teachers was just the simplest way.
Right, and I take it clergy weren't included.
I don't know. I don't think so.
No, that'll run you into other problems, yeah.
And you must understand that the mandatory reporting provisions in Queensland relate to child harm, so it's a much broader spectrum of matters than simply sexual abuse. If you look at the Education General Provisions Act, for example, in Queensland, which I have a lot to do with, you will see that there is a specific reporting provision, mandatory reporting provision, on school staff in relation to any sexual abuse. And that was amended only a couple of years ago in respect of a report authored by Dr. Ben Matthews from the Queensland Griffith University, I think, or QUT. I think you'll forgive me, I think it's QUT, where he had examined the nature of the mandatory reporting provisions in Queensland, and we changed them. It used to be you only had to report the sexual abuse committed by another teacher. Now it's broader.
So if it's happening in the home, it has to be reported if the teacher knows about it?
In the course of their duties, yes. But there is no criminal offence related to the non-reporting in the Child Protection Act area. It's not an offence. The only comeback, I suppose, you have against a person who's a mandatory reporter who doesn't report is really an administrative one, such as discipline.
So it's not an offence not to report?
Not under the Child Protection Act, no. There's an obligation, but it's not an offence. Unless you... I haven't explored the question of whether there's a provision in the Queensland Criminal Code that applies in relation to people who have a duty to do something, and if they fail to do it, there's a default term of imprisonment that applies. So I don't recall specifically whether or not that has been ameliorated in terms of that particular obligation.
It's odd to have an obligation without a sanction, but...
Well, I think as I said, I'm not speaking on behalf of the State of Queensland in relation to this, but I would say that the thinking there really was because the Carmody report was trying to triage the number of reports that were coming into the child safety system. About 80% of matters reported were not acted on. They didn't reach the thresholds necessary for child protection statutory action, and they were effectively clogging up the system and wasting time and taking resources away from what considered the core concerns, really the sexual abuse and severe other abuse matters. So I think the thinking probably was that if we make it an offence provision, that's going to encourage people to report everything, rather than give effect to the policy aim of the reforms, which was to only get the most important stuff reported.
Well, you could do that by making it an offence provision in relation to the important matters, couldn't you?
Perhaps, yes.
Yeah. Yes, Mr. Stewart.
Mr. Davies, in your role in the prosecution service, did you have any involvement in other cases where there was some Jehovah's Witness element to it, relevant element?
Not that I recall.
Those are my questions, Your Honour.
Does anyone else have questions of Mr. Davies?
Yes, Your Honour.
Anyone else? No. No. Yes.
Thank you. My name is Coyne. I represent Dino Ali, Kevin Bowditch, Ron DeRoy and others in these proceedings. Mr.
I
Davies,
think you need to just identify they're elders of the Jehovah's Witness Church.
who are each elders in the Jehovah's Witness Church. Mr. Davies, you made a statement on the 8th of July 2015. Correct?
Yes?
That statement was about your dealings with members of the Jehovah's Witness Church as part of the prosecution of someone. Yes?
Yes?
Yes. In that, did that include Mr. Dino Ali? Did you deal with him?
I don't recall specifically. I did have access to the committal transcript.
Yes.
But I didn't check it specifically. I do recall that I led evidence from the elders, at least in relation to the first appeal matter, but I can't recall specifically who they were.
Do you recall which elders made statements in relation to this matter?
I recognise the names DeRoy, Ali, Bowditch. Those are the ones that stick in my memory.
Yes. As elders who made statements in relation to the prosecution.
That's correct.
Yes. You say in your statement that you did not have any difficulty in obtaining cooperation from witnesses I examined who were in the main lay representatives of Jehovah's Witness Church, correct?
Correct.
Would that include those three persons that I've named?
Yes.
Yes. You've said, I do not recall any reluctance or hesitation to assist me in obtaining records in question in relation to the proceedings.
Yes.
Yes. And you've also said, I do not recall feeling that they had been uncooperative or mendacious in any respect.
Yes.
And that's referring to the witnesses again.
That's correct.
And that would be the three named people before, Ali, DeRoy and Bowditch.
That would be inclusive of them. I don't recall any problem with any of the witnesses really in the matter that I dealt with.
And you requested statements for the prosecution, which they made.
Well, I didn't request them. They would have been prepared and obtained by the police.
Yes.
They would have been part of the prosecution brief before I ever obtained the matter. But I may have spoken to them on the phone before the hearing. If, for example, the matter was going to be full evidence,
Yes.
that's just my memory of it, I might have wanted to speak to them and take them through their evidence beforehand, effectively, conferencing them, and then I would have led their evidence in court. But that's probably the only contact I would have had with those particular witnesses.
Yes. If you had to characterise their statements from a prosecution standpoint, would it be correct to say that they were corroborative of the complaint?
I think so.
Would you also say that they contained alleged admissions of the accused?
I think if they didn't specifically contain them, they certainly referred to them.
Yes.
Because I think there were, from memory, there were admissions outlined in other documents that we obtained directly from the Watchtower Society, I think, from memory.
Yeah.
And there was a solicitor I spoke to, and I had to organise a subpoena for documents.
Yes. So each of those statements of De Roy, Bowditch, Ali, were all in support of the prosecution of the accused.
Yes.
Thank you.
Yes, no other questions? Mr Stewart?
Nothing further, Your Honour, for Mr Davies.
Thank you, Mr Davies. Thank you. That concludes your evidence and you're formally excused.
Thank you.
Might I also be excused, Your Honour?
Oh, yes, certainly. I'm sorry, Mr McMillan.
The witness whom I would call next ordinarily will take some time, and given that we've committed to have the expert witness of the Watchtower Society on Friday, it means that that witness's evidence would hang over at least tomorrow and part of
Well, I
Friday.
think we're travelling well in accordance with our schedule, so we're not troubled by adjourning now, if that's what you're asking.
Well, that is what I'm suggesting.
Okay, all right. We'll adjourn until 10 o'clock in the morning.
Friday.
Oh, sorry, 10 o'clock Friday morning. Yeah.
Oscar.